Hello and welcome to the UK India Business Council and Trilegal's presentation on the Maternity Act 2017. We're joined today by our expert speaker, Swanima, who is a counsel at Trilegal's office in Bangalore and works as part of their employment practice. She has worked with both domestic and multinational clients on a wide range of employment matters, including structuring senior management contracts and remuneration policies, advising on effective management of resignations and terminations, including strategy for senior management exits. She has also assisted clients through disciplinary inquiries, reorganisation and closure of their businesses in India. Without further ado, I'd like to pass you on to our speaker.
Thank you, Becky. Good morning, good afternoon, everyone. As Becky mentioned, what we intend to talk about today is amendments to the Maternity Benefit Act. You all must have heard about it. It's been in the news, and this is something everyone is talking about. It's been over a year since there's been discussions with different houses of parliament passing it, and finally now it has received the president's assent and it's in force. It was in August last year that the upper house, in fact, passed this amendment, and we were expecting the law to come into force by December, which was the next session. But unfortunately that didn't happen. There were some changes. There was demonetization that was brought in, and the focus was shifted. So it was finally this year in March that the Lok Sabha passed the bill as well, and the President gave his assent, which then resulted in it becoming law. The government has finally published a notification appointing the effective date, which means from 1st April 2017, the changes are effective and are in force. There are multiple changes, and we will go through the changes during the discussion today. But most of the changes are in force now, except the provision on crèche, which will become effective 1st July 2017. So just to briefly look at the topics that we want to discuss today. Just give me a moment, I'll change the slide. Yeah. So what we would discuss is, and this is just to give you an overview of the various topics we'll be covering during our session today. I'll focus on the benefits that was prior to the amendment. We will then discuss the changes that have been brought forth by the amendment. And then we'll have a quick snapshot of what are the changes, what was the law before, how the law has changed now. We'll discuss the payments that need to be made, the protection to employment, your ability to terminate an employment of an individual, or whether they are protected and what is the duration of this protection. Some of the key concerns that people have been raising with respect to the amendment, and lastly, we will discuss some challenges with the implementation, and also obviously the potential workarounds and what we believe the likely answer to those questions are. So moving on to the next slide on benefits prior to the amendment. This will just give you a snapshot of the leave entitlements that the earlier law provided for. Right, sorry. So the leave entitlements that were provided for under the earlier law, there is maternity leave. Obviously, that is the key provision under the Maternity Benefit Act, which provides for 12 weeks of maternity leave. Now, of this, a minimum of 6 weeks had to be taken post childbirth, you could take more, but you need to mandatorily take a minimum of 6 weeks. In addition to the 12 weeks maternity leave, the Maternity Benefit Act had provisions on leave for tubectomy operation, which is a 2 weeks leave period. There's also leave for miscarriage or medical termination of pregnancy, which is 6 weeks leave following the day of miscarriage or medical termination of pregnancy. And in addition to all of this, an employee can take another 1 month of leave if it is for reasons of illness, and if she is able to demonstrate it along with a doctor's certificate, then she can take up to 1 month of leave. Now, what is interesting and important to note here is, unlike some other jurisdictions, this leave is paid leave, so the employee is entitled to her salary during the period of leave, and she gets 100% of her salary during the period of leave. What is all the more interesting is the entire salary and the cost of the salary needs to be borne by the employer. So it's unlike in some, in some other countries where the government bears a lot of the cost, here the companies or the employer needs to bear the cost, right? So you would see the leave prior to the amendment was 12 weeks, and this was one of the key debates that various parliamentarians and the Ministry of Women and Child Development, they had raised issues and concerns around this. The ILO recommendation, that is the International Labour Organization, their recommendation is to have 14 weeks of maternity leave. The mandate by the ILO is 14 weeks of maternity leave, while the recommendation is 18 weeks. Now, India is not a signatory to this, but this is the general standard, and throughout the world we saw trends where various countries were increasing their maternity leave, and a large number of countries were above the mandate, and that was one of the major push to change this law. There were also various surveys done by various industry bodies where they figured that while the women workforce in companies, the number of women employees is really high in the first few years of their career. As they progress up the ladder, there was a decline in the man-to-woman ratio in the workplace, and a lot of it was attributable to childcare responsibilities, and therefore an attempt made by the government was to increase this benefit, so to bring about a work-life balance and also help women take the period off and then come back to work. Moving on to the next slide. In addition to the leave entitlements that we just discussed, there are also certain other benefits that the Maternity Benefit Act provides for. This is a medical bonus, which is a one-time lump sum amount that the employer is expected to pay the employee. It's a very small amount. It's INR 3,500 rupees, which is about 44 pounds. So not a significant amount, but this amount needs to be paid in addition to the regular salary that is paid to the employee. It's just a one-time payment during the entire period of maternity leave. Now, one condition is this amount only needs to be paid if the employer is not providing any prenatal confinement or postnatal care for the employee. What happens in India is a lot of companies end up getting insurances for their employees, where they cover the insurance for medical, any medical issues, illnesses, and also maternity-related expenses. And if you as an organization have got that insurance and you are providing that benefit where the insurer takes care of the expenses during the maternity leave, then this is not an amount that would be required to be paid, right? In addition to the medical bonus, the Act also provides for nursing breaks. So till the child reaches 15 months of age, the woman is entitled to 2 additional daily breaks for nursing. This is in addition to the normal interval of rest that every employer, irrespective of man or woman, gets in a day. The woman gets 2 additional daily breaks for nursing. Now, the duration of these nursing breaks varies because India has a federal structure. So there is a central statute, and then there are state laws or rules which further define the statute. So the exact duration are provided under the state rules and tend to vary. It could be 15 minutes or 20 minutes, depending on which state you're located in. Now, moving on to the benefits that have been introduced by the amendment. If we move on to the next slide. So as I was mentioning, all provisions of the amendment are effective from 1st April 2017, except for provisions around crèche, which will be effective from July 2017. So let's quickly look through the benefits that have been introduced by the amendment. The most significant and talked about change, obviously, is the increase in the paid maternity leave. This is a significant increase, I mean, more than double. So the period of paid maternity leave has been increased from 12 weeks to 26 weeks. Correspondingly, you can not more than 8 weeks of this leave shall precede the expected date of delivery. So you can take a maximum of 8 weeks before childbirth, and the remaining needs to be taken later. Now, that's something which has been discussed, debated, and I think the biggest concern here is the fact that the employer needs to bear the cost, and we will discuss the concerns in a bit, but that's one of the criticisms that the law is getting. So while majority and a lot of people are really happy with the change and they believe that it will be definitely a welcome change, there are equally a number of people who have a concern on whether this change and imposing such a obligation on the employer where they have to pay about, say, 6 months of salary will disincentivize them from hiring women, and that's one of the biggest debates, and we'll discuss that in a bit. In addition to maternity leave, certain new age benefits have also been introduced. I mean, over the last couple of years in India, there have been an increase. You will see increased number of people taking off for IVF treatments or surrogacy leave and demanding for that. So that's something which has come up in the last 3 to 4 years, and that's something that the government has recognized and introduced surrogacy leave, which is for a period of 12 weeks for the commissioning mother. Now here under the Act, there is a specific definition for commissioning mother. So a commissioning mother should be someone who's the biological mother who uses her egg to create an embryo implanted in another woman. So there is a specific definition of commissioning mother, and this commissioning mother is entitled to 12 weeks of leave. The law has also introduced paid adoption leave, which is again 12 weeks from the date when the child is handed over. The condition for being eligible to this leave is the age of the child must be less than 3 months. So that's the condition, and if the child is less than 3 months, you are entitled to an adoption leave. Now, a couple of things to clarify here. All these benefits are only applicable to women employees. So a male employee cannot claim an adoption leave under this law. In fact, again, another criticism of the amendment is there is no reference to paternity leave. Now, India is one of those, I think one of the few countries I would say where we do not have any mandatory paternity leave for employers or employees in the private sector. While the government sector, they have recognized the concept of paternity leave and employees do get that. In the private sector, there is no statutory requirement to offer paternity leave, and this was again not something that was introduced by this law or this amendment. Moving on to the next slide. In addition to the benefits and the leave benefits, another benefit that has been included is crèche facilities. And this is an interesting benefit. So obviously, this makes it much easier for working mothers because the government now expects organizations to have that employers will have a crèche and employees will be given access to the crèche. Now, this is also one of the biggest, one of the provisions which has faced the most criticism, and employers have a lot of concern around this provision. The reason are largely because real estate, the cost of establishing a crèche, the liability that comes across along with maintaining crèche. So these are some of the concerns that companies have. And we will spend some time on crèche in a bit. But just to give you a general idea, there is an obligation on employers with 50 or more employees to provide crèche facilities to women. You will notice here that the word used is 50 or more employees, which means irrespective of male or female employees, as long as your total workforce strength is more than 50, you need to have a crèche in that establishment. Women are allowed 4 visits to the crèche per day, and this is in addition to the nursing breaks. There is also an option to work from home. Now, this is more like a directory. It's not a mandatory provision. The law simply provides that both the employer and the woman, if the nature of the work permits, they can get into an arrangement where they discuss the work from home and the employee can start working from home. Now, the provisions around it is quite flexible, and it's completely on the individual employee and the organization to come into a mutually agreed terms and conditions on how they want this work from home arrangement to work. Now, in addition to this, a provision that has been notified and included in this new law is the obligation to notify employees about the benefits. So the employer is required to inform every newly appointed employee about the benefits in writing and electronically. Now, the usage of the word "and" also brings forth a lot of practical issues for a lot of companies, because it says both in writing and electronically, which would, from a strict, if you were to give it a strict reading, it would imply that merely putting up the policy on the intranet is not enough, and you also need to give the employee some sort of a written communication. One question that often comes up and people ask us is, should we include this as part of the offer letter or the employment contract then? My recommendation would be no, ideally not. The reason being that anything which is contractual in nature, amending those provisions become difficult because you always need to go back to the employee to take consent if you want to make any changes. It's best that you communicate these by means of a unilateral policy, because then you have more flexibility on changing these, and you don't need to go back to the employee and get their consent before changing. So the way I would say probably makes sense to go around the implementation is when your employees join and when you're having an orientation session, you tell them about the benefits under the Maternity Benefit Act. If you're handing over your employment contract or the company handbook to the employees, you can also include a one-page document on the maternity leave. But this is something which needs to be incorporated into your HR processes, because that's something that you need to take care of going forward. Now, moving on to the next slide, we will look at the quick comparison of the changes that have been brought about by the law. So if we look at the table in the next slide, The maternity benefit or the leave has been increased from 12 weeks to 26 weeks. Earlier, you could not take more than 6 weeks prior to childbirth. Now you cannot take more than 8 weeks prior to childbirth. Now, one interesting point to note here is this benefit of 26 weeks will only be applicable to women who have less than 2 surviving children. If a woman has more than 2 surviving children, then she is only entitled to 12 weeks of leave and not 26. So from the 3rd child onwards, you will only be entitled to 12 weeks of leave. Nursing breaks, earlier there was a provision on nursing breaks, and that was 2 daily breaks for nursing. Now there's also a new provision which says the woman is allowed 4 visits to the crèche. The leave for tubectomy, leave for miscarriage, medical termination of pregnancy, and the 1-month leave that we talked about for any other illness related to this, all that remains unchanged. So in addition to the 26 weeks, a woman could take another 1 month of leave if it is supported by medical reasons and a doctor's certificate. Right? The new provisions that have been introduced are adoption and surrogacy leave, which was not there earlier. Provisions on crèche were not there earlier. Option to work from home has been introduced, which wasn't there earlier, and also the obligation to notify the employees about the benefits under this act. Now moving on to discuss the payments that the employer need to pay. If we just go to the next slide. Now, as I was discussing and I mentioned earlier, unlike other countries, in India, the employer needs to bear the cost of the leave, and the employer needs to pay 100% of the employee's salary during the leave period. There is really no government subsidiary. Now that's one of the concerns because, I mean, with increasing the leave to 26 weeks, I mean, India is now one of the top countries in terms of the amount of paid leave that we offer to women employees. But then again, the burden here is placed on the employer. And that's something which comes out as a concern. Now, there's only one exception, and there's a very small group of employees for whom the government does bear the expense, and that is employees who are covered under what is called the Employee State Insurance Act. This act only applies to employees who earn 21,000 rupees or less in a month, so that generally forms a very small portion of the employee group that you would have. Now, for these employees, there is an obligation on the employer and the employee to make monthly contributions to the Employee State Insurance Corporation. And therefore, when an employee then goes on maternity leave, the cost of the leave and the salary payment is borne by the Employee State Corporation, and the employer does not need to bear the cost. Now, for all your other employees, it is the employer who would need to pay the salary. Now, the question that often comes up is, what is salary for this purpose? And in India, and those of you who are familiar with the compensation structure in India, it is a little more complicated because you wouldn't have a lump sum salary amount. There is always a basic salary, and then you break down the salary into multiple components like a house rent allowance, a conveyance allowance, a special allowance. So there are multiple allowances, and the total amount is then paid on a monthly basis. Now, the way the law is worded and various cases, the requirement is to take all these allowances into consideration. So the employee is entitled to all her guaranteed components. So if you're paying HRA or conveyance allowance on a month-on-month basis, and that's a guaranteed payment, you take all these amounts together, and that entire lump sum amount needs to be paid to the employee. So that's on the components that needs to be covered. Another question that I'm often asked is, what about bonuses? And it's very common for companies to give performance bonuses or discretionary bonuses, or generally have a bonus component as part of the salary. Now, the bonus component need not be considered while calculating the pay, as long as you can justify that it is purely a discretionary bonus. The moment it becomes a guaranteed bonus, which an employees have a right to receive, it would come within the the definition of wages for the purpose of this act, and therefore would need to be paid. Now moving on to the next slide, we'll discuss what are the employment protection that individuals have while on maternity leave, when they are pregnant, etc. So the law on this is that the employment cannot be terminated during the period of maternity leave. So this 26-week period or any other leave that the employee has taken pursuant to the provisions of this act, which could be surrogacy leave, adoption leave, or leave arising of illness or tubectomy or whatever the different kinds of leave that is allowed under the act. If during the period of that leave, the employee enjoys a protected employee status, and therefore you cannot terminate the employment during this period. You cannot even serve a notice of termination prior, such that the last date falls within the period of leave. So that's an absolute protection that employees have. Now, during the period of pregnancy, that is while they are pregnant but have not really started the leave and they're still within the organization working, you could proceed with a termination. Now, couple of things. Obviously, you should be really careful when you go ahead with termination at this stage, because someone could challenge it on the grounds of targeting the individual, victimization, etc. So you should be really careful and be sure that you have strong commercial reasons for the termination and that you have followed the process that is required under law before you go ahead with the termination. Now, in addition to that, there is also a requirement that the employer pays for the duration of maternity leave. So if we just take an example, say a woman is in the 4th month of her pregnancy, and there is a redundancy in the organization, and you are letting go of the entire team working on that project, and you want to let go of this particular woman employee, you could proceed with the termination, but you will have to still, in addition to all the other payments that, the normal payments that you make to employees at the time of severance, you will also have to pay the maternity benefit, which will be the 26 weeks of pay, and the woman will be entitled to that, right? The only exception to this requirement is when the termination is on grounds of gross misconduct. Now, gross misconduct under the Maternity Benefit Act has a specific definition, and it means instances where there's willful destruction of the employer's goods or property. There is an assault where the employee has assaulted a superior or a co-employee. There's a criminal offense against the individual involving moral turpitude resulting in conviction, theft, fraud, dishonesty in connection with the employer's business, or a willful non-observance with the safety measures, etc. So if you are terminating on these grounds, you need to follow process, which in India means you issue a show cause notice, you give the individual an opportunity to respond, you follow the entire disciplinary process, and then only you go ahead and terminate. If the termination is on grounds of gross misconduct, then you don't need to pay the 26 weeks leave. Right, and the last requirement is you cannot vary to the woman's disadvantage any of the conditions of her service. Now, what this typically means, you cannot take away a benefit just because she's on maternity leave or that she's pregnant, and to that extent, they enjoy some protection. Now moving on to the next slide, we'll just discuss the key concerns with the amendment, and what this amendment has done. There are people with different views, and then people have been largely split into two groups. There is one group which believes it is really a welcome change and that it will address the issues that we were facing of employee drain in the workplace, where you had a lot of women employees at junior levels, at the entry level, but that the numbers would go down as you go up the ladder. So there are people who believe that this would be a welcome change, will ensure that women do not drop out of work and they continue to work, because this helps them bring that balance. There was also this assessment that the Ministry of Women and Child Development had done and said it is essential for the child's healthy growth that the mother is available during the first 6 months, and these were the objectives why the change was brought into force. But what the other faction or group of people are saying, that it may definitely have a negative impact on hiring and gender diversity. Now, one of the, as I was saying, the biggest concerns here is you're making the employer responsible for payment of over 6 months of salary, which may act as a disincentive for employees to then hiring women. Now, we do not really have very strict laws on what kind of questions you can ask during interviews, or what is the diversity ratio that you need to maintain in the organization. And questions like, have you been married? How long have you been married for? What are your family plans? I mean, these are questions which are not unheard of. We have seen instances where recruiters have asked these questions, and the fear is that these questions will become even more dominant and it will have an impact on the hiring decision. So probably it could lead to a negative impact. I mean, in fact, in one of the ILO reports, the ILO itself was of the opinion that if you want an ideal maternity leave benefit structure, it's best not to put the burden of cost on the employer, because it is a conflict of interest per se. I mean, it makes sense for the government or any other association to bear the cost than putting it on the employer, because that's not an ideal situation. So that is one of the biggest concerns. There is also no provision on leave for fathers. So as I was saying, there is no paternity leave, there is no concept of parental leave. So the entire childcare responsibilities is on the woman, and at least in terms of the leave provisions, right? So we had spoken to a lot of organizations, both small, medium-sized organizations and the larger ones. And we saw an interesting trend. The trend that we saw is for the larger organizations, especially in the IT and services sector, they didn't see it as being too much of an impact. A lot of companies were of the view that, they anyways, before the amendment, had gone ahead and increased the maternity leave entitlement. Some companies told us that they did a cost-benefit analysis, and they figured that the cost of training a new recruit is far more than the cost of leave, and therefore it makes sense to let people have that time off. A lot of companies also saw this as a tool to attract talent, retain talent, and therefore went ahead and offered higher benefits, and they're comfortable to do so. But these are all organizations who operate on a larger profit margin, and then the large organizations who are happy to give this benefit. When we spoke to the mid and small size organizations or the startups, and as you would know, startup is a new trend in India, where in the past few years there have been a lot of startup organizations. So when we spoke to them, the sense that they got we got is, since they are working on extremely thin profit margins, this would have an impact on the hiring decision. In fact, there was a survey done by one of the organizations, and they figured that, I mean, they targeted small, medium enterprises, and the result was about 40% of the people who were surveyed said that yes, this new law will play on their mind when they are sitting for interviews and taking hiring decisions. And there were about 26% of the companies who outrightly said that, listen, we would just prefer hiring men instead. So that's one of the biggest concerns. I mean, it also depends on the kind of role, where the role requires a lot more skill set, and in the service industry, I guess the impact will be lesser, but where it is largely more of a process-driven role, the impact may be higher. So we will have to wait and see. Probably it may make sense for the government to think of coming out with some diversity ratios that companies should consider maintaining, probably give companies some sort of tax incentives or other SOPs to ensure that they have those diversity ratios. So that's one of our recommendations to the government, and we're hoping that that would come forth. The other, and obviously this was also something which was discussed in the parliament, is looking at parental leave and introducing a concept of parental leave where both the man and the woman can share the responsibility of child care. It's for the couple to decide how they split the leave. And I mean, obviously, the woman needs a certain period of leave for medical reasons, but after that, it should be ideally for the couple to take the call on how to split the leave. And the benefit, obviously, is that it is not, it's not impacting only one person's career aspirations, or the entire burden is not on one person. It's something which both people decide, and it's completely up to them on how they take the leave. So these are some of the considerations and solutions that is being offered, and let's see where that goes. But for now, the law is what it is. It's in force, so the maternity leave has been increased, and there are no provisions on paternity leave or childcare leave for fathers. Now, moving on, I think, to discuss the challenges with the law and the challenges that companies face with implementation of the law. Now, the law has been made effective from 1st April, as I told you earlier. Now, the question that comes up is, who will this benefit apply to? So is it only to employees who've given birth after 1st April? Will it apply to employees who are on the statutory maternity leave? Will it apply to them also, even though they gave birth before 1st April? What about those employees who have been given unpaid leave or extended leave by the organization? Can they take care of this benefit? So these are some of the questions that organizations are asking. Unfortunately, there isn't much clarification on this. We have written to the government. We've had multiple discussions with them, and we understand that they are likely to come out with clarifications during the course of this week or next week. But just to give you an idea and how we believe this could potentially go, definitely people who give birth after 1st April, I think the position is very clear. The leave and the benefit will apply to them. With people who have finished their statutory leave, who have finished the 12 weeks of leave and are either on unpaid leave or on extended leave, which is granted by the employer at his discretion, my sense is that they will not be legally entitled to claim this benefit because they've already fallen outside the purview of the Maternity Benefit Act. I think the only gray area, and the area which is really unclear, is people who are still within their 12-week period. Now, if we were to draw a reference, the other law that I was talking about earlier, the Employee State Insurance Act, which applies to employees who earn INR 21,000 or less, This law was also amended recently, earlier this year, where even under this, they increased the maternity benefit period from 12 weeks to 26 weeks. While implementing this law, they made it applicable only to people who gave birth after the effective date. So people who were on leave were not entitled to this benefit. There was also some tweets by the Ministry of Women and Child Development, which said the same thing. They said that it won't be applicable to people who have given birth prior to 1st April 2017. But the Ministry of Women and Child Development will not be the appropriate ministry, and we'll have to wait for the Ministry of Labour to finally come out with clarifications. So that's one area that we are waiting for clarifications on. Now, similarly, the position for adoption and surrogacy leave, who would be eligible if, say, a woman has adopted a child before 1st April, would she still be eligible to the benefit? In my personal opinion, I think she should be. The only thing, the leave would be reduced. So if it was a week prior to 1st April, she would only get the remaining, which is 11 weeks of leave and not the entire 12-week period. So you would count the remaining period from the date on which the law became applicable. But in my opinion, they should be entitled to it. Obviously, we will have to wait and see what the government clarifies in this regard. Now, moving on to the last slide, and one of the most debated and talked about issue is the crèche facilities, and this is one of the biggest concerns that companies have in India. There are constraints around real estate. Most of the companies operate out of IT parks, and they really don't have space to build up their own crèche facilities. Companies also have a concern on the risk that and the liability that could come out if they were maintaining their own crèche facility. The question also comes up is, can I charge the employees for this crèche facility, maybe even a subsidized rate, or is it absolutely free of cost? What is the distance of the crèche from the establishment? Now, in one of the earlier drafts of the bill that was being circulated, they had mentioned that the distance should be 1 kilometer from the establishment, but that was later changed, and the final act, which has come into force, says it will be within such prescribed distance as the government may come out with. So we have to wait for the government to prescribe that distance, but given it was 1 kilometer earlier, it should give you an idea of what it could be. Again, a question comes up is, till what age can a child be kept in the crèche? We do not have a ready answer to that. If we look at some other laws in India which provide for similar crèche facilities, like the Factories Act or the Contract Labour Act, they normally provide for till the child is up to 5 or 6 years of age. So probably that again could be a benchmark here, but we will have to wait and see what the government provides for. The other question that is coming up is, are the visits to the crèche? So there are about 4 visits that have been prescribed in the amendment. So are these 4 visits in addition to the 2 nursing breaks, thus making it a total of 6 visits to the crèche in a day? And then we will need to see what stance the government takes on that. But if it is indeed 6 visits, which seems to be the case, then it is in the company's interest to ensure that the crèche is located close to the establishment, because otherwise a lot of time would go in travel. So these are some of the concerns on whether it needs to be free of cost or not. Again, if we look at other statutes, the Factories Act, the Contract Labour Act, the requirement under those, the expectation is that it will be free of cost, and then that's what has been provided for. But we'll have to see whether the same will apply here. Currently, the companies that are providing crèche facilities, they are mostly, in my experience, charging a subsidized rate. from the employees, because a lot of them do not have it in-house. They have tie-ups with service providers, and they charge the employees a subsidized rate for it. So we will have to wait for clarity on this. Now, thankfully, these provisions are not in force yet. They will become effective only from July 2017, and the government is working on rules to clarify some of these issues, and we expect that we will know more about the crèche requirements and the expectations from our organizations in the coming months. So with that, I conclude the presentation. You should have my information on the last slide with my contact details and email ID. If you all have any questions, you can either reach out to me or you can reach out to Rebecca, and then we'll be happy to assist and get back to you. Thank you.
Thank you very much for that very informative and detailed presentation. Before we do finish up today, I have a few questions, if you wouldn't mind answering these. So the first one is, how do companies manage the impact of maternity leave on an employee's performance rating?
Right. That's a very interesting question, and again, as I was mentioning, in India, it's very common for companies to have a performance-linked bonus, and employees have an annual appraisal system where they get a rating, and based on their rating, they get a payout. Now, the question that comes up is, if an employee is out of the organization for, say, 6 months, then what do I do? Is the performance payment prorated? I mean, there is no legal requirement around this, the reason being that it's completely a discretionary benefit. So there's really no legal requirement to pay out the amount. In my experience, a lot of companies just decide that, listen, since the employee is not performing and the payment is attributable to meeting certain performance targets, we take a call not to pay any performance bonus at all. While some other companies take a more employee-friendly approach, and I've seen some companies decide that they will apply the previous cycle's performance rating. They will use the same rating and apply that rating to pay out the amount.
Great, thank you. Next question is, how is discretionary bonus calculated?
Right. So again, just discretionary bonus, and the question that I was discussing earlier is, do I need to pay this amount at all as part of the salary? As long as your discretionary bonus policies are worded in a manner that it is completely discretionary, it is at the will of the employer, you have no right or expectation to receive it, there is no obligation to pay this amount. And therefore, some companies take a call to not pay it at all, while some pay out the prorated amount.
Thank you. And we have one final question. Can alternate workforce be appointed? And if it can, what are the options available?
Right. That's again, I think, one of the most frequently asked questions, because you also need to see the continuity of business, and if the role is, if someone is going to be out of the workforce for about 6 months or sometimes about a year, you need to look at alternate workforce. Yes, it's very common for people to appoint alternate workforce, either as independent contractors or fixed-term employees, or as contract workers, or what you call as agency workers. So you get a third-party manpower supply agency to depute, say, 1 or 2 people in your organization for the period that the employee is on leave. So those are some of the common arrangements that employers look at.
Brilliant. Thank you very much. And thank you for anyone listening. If you have any questions, as Sonny mentioned, please feel free to email herself, or you can email me at events@ukibc.com. Thank you.